Good evening and welcome to another edition of You and Your Money. I'm your host, Bryan Hirsch, and in tonight's program, we're once again focusing on estate planning, which hopefully is offering insights and guidance to help you make informed decisions. The cornerstone of both an estate and financial plan is an up-to-date will. Any contract entered during one's lifetime can be challenged as the parties are still alive. However, upon death, the instructions of the will are final and must be carried out by the executor in accordance with the deceased's wishes. In addition, trusts are a valuable estate planning tool that can help ensure continuity of lifestyle and provide long-term peace of mind and financial security for you and your family. And joining me this evening are my resident guest, Harry Joffe, Head of Legal Services at Discovery Life. And for the second time, I welcome Terry Berkowitz, attorney at Terry Berkowitz and Associates. Terry, great to have you on the show. Harry, nice to have you back with me. So let's put my first question. There's a lot of debate whether spouses should have a joint will or a separate will. I'd like to hear your comments on that.
When it comes to joint wills, I like my clients, if they have a joint will, to make sure that two joint wills are signed, two wet ink joint wills, because the problem is it's more an administrative burden, because when the first spouse dies, the original joint will is submitted to the master, and then there is no other joint will when the second spouse dies. So that's the administrative headache that happens, in that on the second dying spouse there's no available joint will. So that I don't prefer either one, but I always advise my clients to rather have separate wills so that we don't have to deal with this issue of the second joint will being lost or not being able to be submitted when the second spouse dies.
Bryan, I'm going to jump in here because
before you do, because my question to you is the Master's Office any better, Harry?
Well, it's a very loaded question, Bryan. But before I even answer that, I'm going to just add on to what Terry's saying, because I always say to our clients, there's nothing romantic about a will. You're going to be dead. Your spouse is going to be living with the next door neighbor the day after you die, spending your money. I've never understood why people want a joint will. I actually cannot understand the logic. It's not something that brings you together. Have two separate wills. It's so much simpler. Legally, it's much easier. As Terry said, the original will doesn't go missing at the Master's Office. You don't have any legal complexity, because often the second spouse now wants to change their mind after the first spouse has died. Can you do that? It's not so simple. So I hate joint wills.
So that is a question. If you have a joint will, Terry, and someone does die, can the other party change the will?
So that's why some of my clients do prefer the joint will, because they actually want to control what the surviving spouse does with the assets on their death. So the surviving spouse can change their will at any stage. They can then decide to leave it to someone else who the first dying spouse didn't want to leave their assets to. So you've got to trust your spouse to make sure that they won't change your intentions.
If you want to control it, rather use a trust, rather leave the assets to a trust and have the right trustees. I mean,
correct.
It means to do a joint will, just so old-fashioned.
Harry, so let's just take the addendum to the will, the living will.
Yes.
Where does the living will fit in, and is it binding on the medical fraternity?
So, Bryan, first question, it's not a will. That living will is actually a misnomer. I don't know why people call it that, because it's got nothing to do with the will, really, because you're not dead yet. And it doesn't form part of the will. So it's a separate document. Now, whether it's binding on the medical fraternity, that is hellishly complicated, and there's so much debate. I would say more important than if it's binding or not is practically, how did the medical community get to know about your living will? I was told about a case a month ago. This chap was going for a run, and he was hit by a car on the side of the road in a coma, got picked up by ambulance, taken to hospital. He had a living will, but no one knew about it. The hospital didn't know, his family didn't know, because they weren't even called in. So how do you make a living will known to people? And Bryan, I'm going to push Discovery here unashamedly. What we're trying to do at Discovery Wills and Trusts, we're trying to link up with Discovery Health, and we're trying to get them to take all our clients with living wills and actually note it on the hospital system. So when you end up at the hospital and you've been hit by a car and you're in a coma, the hospital can know about this living will. If they don't know about it, who cares about the law? It's not going to happen. And that's why it's such a tricky issue.
Okay, so let me ask this question. I'm on Discovery. So I haven't had no notification. I've got a living will. My wife's got a living will. We've had no notification about linking that up to a healthcare program.
Oh, we haven't done yet. We're still working on it, Bryan. Trying to get this into the hospital system is a year task. So we're only a couple of months into it. Okay. We'll get there by next year. Right. Before Man United winning another game, we'll be there.
So Terry, you wind up a lot of estates. You've been doing a lot of winding up for my clients, unfortunately, who've passed on. Why does it take, just explain to our viewers, why does it take so long, and what can you do to speed up the process?
So firstly, clients don't understand the processes that are involved in terms of the legal requirements. There's a 12-step process, which I want to briefly outline so that your clients and my clients can understand, because normally they'll send me messages and they'll say, wow, this is a process. So no one really understands the legal process of each step and each stage.
And we only got 26 minutes.
Okay, 26 minutes, but there's 12 different steps, from getting your letters of executorship, advertising to your creditors, opening estate-late bank accounts, writing to the institutions, then getting your closing balances, coding the estate with SARS, doing the LND, then advertising the LND at the master and at the magistrate's court, getting permission to distribute, getting the SARS clearances, and getting your discharge summary. I hope that was quick enough. But
You did your homework.
I did my homework. So I've given you basically the steps, and within those steps is a long process under each of those items.
Okay, some of them seem very simple.
Yes.
Which are the stumbling blocks?
The Master of the High Court has many delays because they just do it currently at the moment. The SARS takes a very long time. SARS will take 21 days to respond to one query. So if something's wrong, you write to them, 21 days to hear back from them. And the banks, 60 days, although Discovery Bank is very efficient, I must
Thank
say.
you, Terry. You'll get your cap after the show.
Banks take 60 days to respond to a query. So if I don't get my closing balances and I write to them, where is it? You can expect to wait 60 days for them to respond. Can't proceed with the LND until I have those closing balances. So it's the institutions and governmental and private that delay the matter.
And Bryan, things go wrong. I mean, heirs fight, and there's a conflict with the executor. Can the executor sell shares in the estate? We have that all the time. What you must do with the investments in the estate. And that just drags it on and makes it slower, because the minute the executor gets dragged into a fight, if the master knows there's a fight, the file goes to the bottom of the pile because they don't like getting involved. So that's if things go well. If things don't go well,
when you
it's
say,
worse.
can the executor sell shares, surely that's at the discretion of who? The executor in consultation with the family.
Well, Bryan, it depends a lot on the will. So a properly drafted will should say the executor either has got
It's got all the powers.
well, if it says he's got discretion on their own to sell shares, then they can. Often it says in consultation with the family. And then, of course, you've got three heirs, one who's bullish on the market, one who's bearish, the one doesn't even know. And then there's a fight, and then what do you do? So actually, I prefer a will. Terry might disagree. I think the executor should have a discretion and not have to go to the heirs, generally. I mean, there might be specific assets which are very personal and you want him to have discretion. But in the main, if it's a unit trust or if it's a share portfolio in Anglo-American, let the executor decide, I think.
Yeah. But then, Harry, let's talk about the delay. The delay therefore puts the family under pressure.
Yes.
Because there's no money coming out. You can't distribute any money, is that correct, Terry? Till you've got a lot of this wound up. So now, what do you suggest the family does with the interim? You've got one spouse dying with all the assets in their name. What are you suggesting one should do with assets so that the family have assets, that they don't have to worry about the winding up of the estates?
So, Bryan, thank you very much. You've teed me up for life insurance. That's a perfect question. I've waited a whole year for that question. So, I mean, life insurance, of course, is the answer. So, if you've got a life insurance policy and you die, you name your beneficiaries on the policy. The beneficiaries get paid out often within 48 hours if there's no issues on the claim. It doesn't go via the estate. It doesn't go via the executor. Of course, it's an asset in the estate for estate duty, but it doesn't go via the estate. And that means the family can get the cash and they can live while it takes 2 years to wind up their estate, number one. Number two, Bryan, you must think about your investments carefully as well. Obviously, you've got different kinds of investments, but we've got an investment wrapper called an endowment policy, which all the insurers offer. And all it is, it's a whole lot of unit trusts or ETFs inside a policy.
It's like a room. You're
Exactly.
buying a room from a company called endowments.
So what is so nice about it is, of course, you nominate a beneficiary on that as well. So, if you've got a unit trust in the estate, that has to be wound up with the estate and it can take the 2 years. If that unit trust is wrapped inside an endowment wrapper, you nominate your beneficiaries and they get paid out again within a few days because it's a life policy. And then thirdly, Bryan, again, unashamedly, I'm going to push Discovery. We got this product, and we're not the only ones with this product, called an estate preserver. And what it does is, if you've got the right executor and the right trustees, which are our people, then this product actually pays the executor fees in full and the trustee fees in full, and conveyancing fees as well. And it just means that your estate has got this liquidity to pay the executor and pay the trustees, so you don't have the problem, which we often get, where the executor says, there's no cash in the estate, there's no liquidity, I don't want to be the executor. And that makes it even worse. But if you've got this product where the executor knows their fees are being paid and guaranteed by this policy, again, that makes it easier. So simple answer to your question, Bryan, life insurance.
Okay. Then to you, Terry, the difficulty of dying intestate without a will.
Yes.
Now share the complications, because 80% of people worldwide don't have wills. I don't know what this percentage is in South Africa, but it's pretty
Similar.
high. Similar amount, Harry?
Similar, yep.
80%.
So the complications is first that you don't appoint an executor who you choose, who you trust, to ensure that your assets will be distributed according to your wishes. Secondly, your assets won't be distributed according to your wishes because it will follow the intestate laws of the government. But having said that, the intestate laws do protect your family. For instance, if you have a spouse and children, it normally goes down that line. But the problem is that there's many delays without the will. If you have minor children and there's no will and no provision made for the minor children, the inheritance for your minor children will be given to the guardian's fund. So the complications of dying without a will is mainly for minor children and the appointment of your executor, and also it not going according to how you wish your assets to be distributed.
Harry, talking about the Guardian Fund,
Yeah.
is that an investment fund, or what actually happens when money goes into the Guardian?
So the Guardians Fund is run by the Master of the High Court, of course, and it goes into a very, very conservative investment. It's normally a money market account in Pretoria, and it's run like that. So it won't,
Until the children of an age, so you could
Until they turn
find
18.
2 5-year-old and 7-year-old money going into Guardian Fund that's going to be sitting in cash for the next 11 to 13
exactly.
years.
And it's not easy to even get the interest on that money out. It's a very bureaucratic process. So the kid goes to school and they want to release income or interest. It takes a long time to get the money out. There's been a lot of complaints about the Guardians Fund and the slowness of it. One point I want to add, Bryan, people think our interstate is dying without a will, but it's also dying without a valid will or an enforceable will. So I'll just give you an example. I had an interesting case recently. We had this spouse whose spouse had died. So we had a lady whose husband had died a year ago. And she was so traumatized, and she was a rare spouse. She was actually upset that her spouse had died. And she couldn't change her will because the other spouse was the heir in her will, but he had now died. She couldn't change her will to take him out the will. She just couldn't do it. So now she is going to die intestate because he's the sole heir. He's predeceased her, and he can't, of course, inherit. So it's an issue to update your will. You might have a valid will, but it might be unenforceable, or it might be out of date so that the heirs have actually predeceased you. And that's a very big issue we find.
Okay, I'm going to have to discuss with Harry during the break the next question, which talks about if there's no cash in the estate and there's all properties. I know Harry's going to want to pay. By the way, Station, if Harry mentions Discovery, name one more, Discovery will be sending a donation to the studio. Please stay tuned. We'll be back shortly.